A of the Senate Judiciary Committee to order. Two bills to be heard this afternoon. The first is Senate Bill 10. Senator Emmanuel Jones, this would be the bill on drag racing and street racing, whatever we're calling it these days. If you're ready to present, come right ahead. I guess we have enough folks here. We're missing a couple subcommittee members, but three of us, I suppose, is a quorum of the five. So we'll proceed because I know we don't have a whole lot of time to hear two bills. Senator Jones, tell us what you got.
Well, thank you, Mr. Chairman, and thank you to members of the subcommittee. I present to you Senate Bill 10, and I am reading off of LC 392870S. And I say that because from the time that I introduced this bill a couple of weeks ago, this bill has gone through several changes, and it's gone through changes because I've attempted to listen to the stakeholders and try and modify the language so that we reach a medium. So we reach an opportunity to really perfect this legislation, and that's the intent today. I'm sorry I can't hear behind the mask, Mr. Chairman.
That's okay. We're socially distanced. You can remove it while you're testifying. That's
and we
fine.
get tested twice a week, so I'm good. But if the subcommittee would allow me, I just step through some of the provisions of the bill and explain why those provisions that are in there.
That would be fine. You just take it at your whatever order you think's easiest for us to comprehend it.
Thank you. Section 1, which is important, this bill is named after J. Mills Sanford. I call it the J. Mills Sanford Law. And behind me sits Ms. Bobby Sanford, who is the mother-in-law of J. Mia, and she inspired me to draft this legislation. A horrific incident where her daughter-in-law was killed and her granddaughter was seriously injured in a horrendous incident in DeKalb County. Sitting next to her is a member of the Jack and Jill Club, a nationwide organization that supports the effort to reduce the incidents that we see related to this bill. And on the other side of her is my commissioner from DeKalb County, Commissioner Larry Johnson. And I forgot to mention a young person, the black suit is Justin Murray, who is a service director who has experience in dealing with these kind of automobiles, and will speak to why certain language is included in here, particularly certain language regarding high-performance vehicles. Section 2 of this bill gets at really the heart of what is considered a growing problem, not just in our states, but really across the country. And this language is in here to get at just not the person that's driving these vehicles illegally on our streets and highways, but also those who are organizing these events and those who are out there actively participating and gambling and waging off of these events. That's the purpose of Section 2. Section 3 deals with definition for a high-performance vehicle, and these are new vehicles, by the way. And Mr. Murray will explain in more detail why we chose a 650 horsepower rating or greater. Been in the car business for over 30 years, I can tell you at my dealership, there's only one car that we sell that has more than 650 horsepower, and it's a Mustang Chevy GT that puts out 725 horsepower. And that car really should not be street legal. Unfortunately, it is. But beyond that, you get into exotic cars. Section 3 also relates to a license plate, if you will, for registering such vehicles. That could be something as simple as a decal on the back of an existing plate to identify a vehicle as high performance, again, over that 650 horsepower. And those rules will be promulgated by Department of Revenue. Section 5 of this bill deals with some provisions related to young people who participate in this illegal activity of drag racing and some of what the consequences are to them related to their driver's licenses. Section 5 deals with mandatory suspension of violations of this code section and what the consequences are to someone's driver's license. Section 6, in this bill, there's graduated punishment. There's the first tier, which would be a high and aggravated misdemeanor. It's 6 points off your license. The second tier, the second time someone violates this code section, the punishment, and that's a $1,000 fine as well. It goes up to a $2,000 fine, and then after that, on the third and subsequent conviction, it would be 12 points off your license and a $5,000 fine. Section 7, code section defines what's meant by drag racing and racing. And over on lines 176, you can again see what those fines would be regarding the convictions. Section 8 of this bill deals with zigzagging, lay and drag, or as some people call it, donuts, and what the consequences would be, which is mirrored in other parts of the bill. Section 9 deals with a provision that was added with homicide by vehicle as it relates to drag racing and lay and drag. Section 10 clarifies the statutes regarding off-road vehicles and that they are not permitted on our state highways. And Mr. Chairman and members of the committee, that's kind of like a high-level overview of Senate Bill 10 as it relates to lay and drag racing.
Okay. Do any of our subcommittee members have questions for the author? Okay. I'll recognize you, Senator Kirkpatrick.
Can you point me to the language about the forfeiture of the vehicles?
Absolutely. Over on line 179, page 8, it says any motor vehicle qualifies as a high-performance vehicle pursuant to this code section 42-48 operated by a person who's been arrested for a second or subsequent violation of the code section is declared to be contraband and subject to the forfeiture in accordance with the procedures set forth in Chapter 16 of Title 9. And this language was changed. I originally had from the original legislation some language regarding vehicles being impounded, and there were some concerns from members of the community about impounding vehicles. So instead of impounding the vehicle and holding it until after case is adjudicated, was the language in the original bill, we put this forfeiture language in here. And that allows a person due process.
I'm sorry, I'm not a lawyer, so you're going to have to help me with the difference between forfeiture and impounding.
And Senator, thank you. And I know you're a surgeon and I'm a car dealer, so we can just talk to each other without all the legalese.
Senator Jones, we may need you to interpret over here in a minute. Impounding, the original language in the bill dealt with impounding, and that's where, and it only deals with high-performance vehicles. So there's only a small class of vehicles that the impounding deals with. It doesn't deal with any of the other vehicles that have been converted. And the language in this bill deals with vehicles that are converted, where people, and that will be a further explanation of how vehicles are converted by Mr. Murray. And this language also deals with high-performance vehicles, new vehicles that are sold with greater than 650 horsepower. And for those vehicles, those high-performance vehicles, really expensive and exotic vehicles, those vehicles would be subject, according to the language on this page, to their vehicle being forfeited if in event they violate this code section.
impounded, the original language, we were impounded where the car would be held in storage until after the case was adjudicated. And the reason why the impounding language was removed is because Legislative Council knew there had not been any Supreme Court rulings on whether or not it was even justified without a conviction to impound someone's car, essentially take it away from them. But this language that's included in here under the forfeiture language, that language has been tested and has been included in other bills.
So just follow up if you
Yeah,
don't mind,
right ahead.
Mr. Chair. So if the vehicle's forfeited, then when the proceedings are over, does the car come back or no?
If a vehicle is forfeited,
It's gone.
that is correct.
Okay.
And there's language in here that speaks to that as well. Starting on line 183, where it says, in any case where a vehicle which is the only family vehicle is determined to be subject to forfeiture, the court may, if it determines that the financial hardship, and that's where the vehicle title can be transferred to a family member. So there is a, quote, escape clause in here.
Senator Jones, I recognize you for question.
Thank you, Mr. Chair. That just brought up another question. On the forfeiture issue, would there be a hearing before the property is actually forfeited?
Oh, absolutely.
Okay. So
Yes.
there would be actual hearing, and you have due process there. And then number 2, going back to page 2, on lines 29, paragraph B. And I had one concern there about where it says any person is knowingly present and actively facilitating. I know in your prior bill it actually had a spectator. How would that not be too overbroad, I guess? How do you, what is your vision when you say knowingly present and actively facilitating? What's the intention there?
Yeah, excellent question, and thank you for giving me an opportunity to clarify this, by the way. In drafting this legislation, the intent in order to curb this growing trend that we see in our state, I wanted to go after those who were not just driving the vehicles, but also those who were organizing these events. And there is some efforts behind the scenes, particularly with social media, to organize these events. Additionally, I wanted those, and there is a precedent on our books. Dogfighting is a precedent, by the way, where our code section allowed those who participate in or present in those events to be prosecuted as well. So that's where it started. That language kind of borrowed from that code section. As it relates to drag racing, the whole intent was not just to go after the drivers or the organizers, but also those who bet on these events and those that are actively participating. It is not my intention to entrap anyone who innocently walks out of their house and happen to have their cell phone and they're recording this event. That is not the intent of this legislation. The intent is to discourage people from attending these events and certainly discourage those from organizing them as well.
Feel free if you have further follow-up questions, Senator Jones.
Oh,
You good? Okay. I recognize Senator Kirkpatrick again. No, that's fine.
I don't have it with me, but I believe that some of us got a letter from the city of Atlanta asking us to do something about the street racing issue because of all the complaints that have come from communities within the city. Had you had a conversation with them about that?
I have, and I believe there's a representative from the city of Atlanta is present. I've been told that the city of Atlanta supports this legislation and the efforts of this committee to perfect this legislation. And not only the city of Atlanta, but as I mentioned earlier, the origins for this legislation came out of my county, the county I represent, DeKalb County. And I do know that the commissioners in DeKalb County, led by Commissioner Larry Johnson and Commissioner Marita Davis Johnson, has passed a resolution asking us, imploring us to do something about what they see as increasing activity that's harming property, and unfortunately lives are being lost. And Ms. Sanford is here to tell you about her loss. And I applaud her and thank her for her courage of being here today to explain the impact that these kind of incidents has had on her family and her life.
Any Further questions? Okay. I didn't realize that these were gambling events, so the spectators are betting on the car races?
And that is correct, Mr.
Okay.
Chairman. And I know Commissioner Larry Johnson is here, and he's witnessed these events firsthand, and he'll be able to share a lot more knowledge regarding his actual experiences and what he's heard in his county as well.
What I had seen, you know, on just news reports is them cutting the donuts in the middle of intersections and really just kind of showing out and spinning around. I guess I hadn't seen the actual drag racing going on. Must be connected with the same type of gatherings or events.
That's correct.
Okay.
And Ms. Sanford, who's here, she's in the real estate business, and they own, her family owns a lot of property in the county, in DeKalb County. And one of the areas where these type of activities are occurring, and she's going to share with you the number of times that she's raised this issue with law enforcement, and this was before her loss.
Okay.
But what has
Well, that
happened
would be
subsequently.
Very
is-
valuable to us. I have a number of witnesses or people, speakers lined up that would like to be heard. I think I have about 7 on the list that signed up. And then I have Miss Jill Travis on the telephone, who we have, she wasn't able to be here live due to COVID reasons, et cetera, but we're going to let her speak first. And then many of the speakers that you've mentioned are on the list. I'm going to ask speakers to try to kind of hold your comments, if you don't mind, to 3 to 5 minutes if we can. We'll be able to ask you questions because Senator Jones has another bill dealing with the statute of limitations on rape and sexual assault cases that we need to hear today as well. So just out of courtesy to him, let's try to be as concise as possible. We're not trying to cut you off, but we can have another hearing if we need to, but let's try to hear as much as we can today. Ms. Travis, I don't know how technologically savvy I am, but we're trying to put you on speakerphone, and as soon as we do, please share your thoughts with us. All right, go ahead.
Chairman Cowser,
Y'all hear?
I'm looking at the screen and seeing your mouse moving, so I'm hoping that that's working okay.
It's working great.
I've turned,
Thumbs up. Can you see this?
yes, I'm watching. Thank you, Cindy. Appreciate everybody's help. It feels so foreign to be here like this. I'm going to introduce you all. I'm Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. We have a lot of sympathy for the issues that are being faced right now today, but we also have a lot of concerns about the legislation that's before the committee. I'd like to introduce you to Maisie Lynn Causey, who's also on the line with me. She's a policy advocate for GACTL, and I'm going to let her speak to some of the issues. I may come in afterwards. We'll pretend we're both sitting at the table right now together.
Good afternoon. Good afternoon. Thank you for having us. We have submitted a memorandum that I know is distributed to you. I hope you will all find it in your folder. I will not reiterate that word for word, but I do want to bring some highlights to your attention. With respect to the forfeiture concerns in this bill, we appreciate very much how this bill has progressed from being an impound situation where someone would just be without any due process at all having their property taken, and how it's progressed now to forfeiture, which is a better step toward something that has some due process built in. Unfortunately, though, it does not prevent this from being an excessive penalty under the Eighth Amendment. We believe that there is still a concern, a constitutional concern with respect to the excessiveness, as well as potentially equal protection. The senator mentioned that this forfeiture only applies to a certain class of cars. So not every person who would be charged with or convicted of street racing or laying drag would be subject to this forfeiture. Only people with these certain types of cars, which we believe would be a constitutional concern worth noting. So when we go to the bill, I'll go through as quickly as I can from the beginning to the end. But starting at Section 2, I heard the senator explain that they are not intending to loop in innocent bystanders. Unfortunately, the language as drafted right now, especially in lines 32 through 35, appears to us to still allow an innocent bystander. For instance, if this was happening in my block, which it does happen near me where I live, if I were just interested, thought it was kind of interesting and funny, I could go film it. I wouldn't be gambling. I wouldn't be facilitating it. I wouldn't be doing any of the things to truly actively facilitate it. And yet, if I were to then post that on social media, I could be wrapped up in this code section and charged. So I just feel like the language needs to be narrowed to actually achieve what the senator's goal is. Right now, it's definitely broader than he says he is intending. And then in Section 3, our concern around the high-performance vehicles falls mainly with respect to line 43. So this idea of converting a car, the only ways, and I understand there might be someone here that's going to testify more specifically. I'm not a car person, but I did speak to my auto mechanic about this to understand how one might know that a car has been converted. And he explained that there's one way to do that is to hook the car up to a dynamometer, I hope I'm saying that correctly, as a way of determining what the horsepower is and then comparing that to the manufacturer's specifications. But all of this would require a search. And at this point, it's not clear to us how anyone would even have probable cause to have stopped a vehicle to claim that it has been converted and therefore should be subject to this registration that it may or may not have been accomplished by the owner. Moving on quickly to the points that are being allocated in Section 6. This falls at lines 148 through 154. You'll notice, the entire code section is there for your consideration, and this point scheme is much more punitive than some really more serious traffic offenses. Our code designates some traffic offenses as serious, and they kind of run up in the 300s. For instance, reckless driving is one of those, and you'll see at line 127 that's a 4-point violation. It is our understanding that the senator does wish to have these points accumulate so that ultimately the license could be suspended. As you all probably realize, once someone has accumulated 15 points over a 24-month period, their driver's license is suspended. So in this particular scheme, the other thing that's happening when people are cited for laying drag or for street racing, there are often other crimes associated with or offenses associated with it as well. So it's very easy to get to that 15 when you start off at 6 or even 8. With respect to within that forfeiture scheme, which is found in both Section 7 and in Section 8, there is this family vehicle exception. This language actually comes straight out of the habitual violator code section for DUIs. And in that context, one must actually have violated the DUI laws 3 times before this kind of forfeiture comes into play. You have to have 3 DUI convictions, be facing your 4th offense in order for forfeiture to come into play in that context. Here we see that it's a second violation, and that is of concern to us. That again, this is kind of falls into that realm of an excessive punishment for a rather low-level offense. And then with respect to Section 10, our concern in Section 10, we understand that the senator desires to penalize folks who are using off-road vehicles on public highways and causing trouble in that way with those particular types of vehicles. Unfortunately, the way this has been drafted, when you put Section 10 and 11 together, it is actually criminalizing a couple of other behaviors that are currently only civilly penalized. So those activities that are outlined in lines 242 through 244 today are subject to a civil penalty of at least $25. And by structuring Section 10 the way it is and capturing these off-road vehicles, unfortunately, it's just over-criminalizing other behavior that really isn't the target of this bill and could be separately drafted to achieve the goal without looping in a whole other cohort of people that are not the focus of this legislation. Finally, we would also like to encourage the committee to consider that these traffic offenses, especially the new ones that are being created in this bill, these affirmatively set out to be charged by citation. Right now in our code, we do need that to be specifically laid out in the language in order to prevent people from having to be arrested, especially when you're talking about a time when we're faced with a pandemic. The fewer people we can have cycling in and out of our jails, the better. And there's really, as this bill is laid out, there's really no additional public safety risk that someone needs to be housed in a jail for once you have arrested them and in this case taken away their vehicle. So we would encourage you to consider allowing this to be charged, any of the new crimes here, allow them to be charged by citation so that we can help mitigate the spread of this virus in our community. And that's all I have for you all today, just getting through that quickly. Bill might have a few more comments behind me.
Yeah, just a couple more points. One is, just to be clear so that the committee understands the concern about forfeiture, well, let's leave equal protection aside. Let's leave due process alone because it's a civil asset forfeiture theme. The case of Timms versus Indiana, which is in your memorandum, is the exact same scenario of where the courts tried to take away a vehicle. It was a Land Rover in this circumstance, when the punishment involved for the crime was a $10,000 fine. And the United States Supreme Court found that that was disproportionate, an Eighth Amendment violation. So in that same spirit, we feel like that the taking away the vehicle in this instance is disproportionate to the crime, even if it's a high and aggravated misdemeanor. And lastly, the punishments on lines 176 through 178, where you've got first convictions mandating a fine of a certain amount, taking full discretion away from the judge. We always like to see discretion provided to a court because we feel like the judges are in the best situation to determine what the punishment should be. And when the legislature sets it so stringently, we bristle a little bit and ask for discretion on behalf of the judges who don't usually come in here and advocate for those kinds of things.
Thank you, Ms. Travis. Any questions for Ms. Travis by committee members? All right. Well, thank you so much for presenting that to us. I had one question on high and aggravated misdemeanors. What's the distinction between a high and aggravated misdemeanor and just a regular misdemeanor, if there's such a thing?
There is only one distinction, and that's the amount of the fine.
For some reason, I thought that there may be more of any jail time would be mandatory under a high and aggravated misdemeanor. I didn't see jail time in this statute, but typically a misdemeanor would be up to a year, right?
Right. Both crimes of a regular misdemeanor and a high and aggravated misdemeanor carry the 12-month penalty. But there are certain crimes that in Title 40 where there is some mandatory minimum times, for example, in DUI. But other than that, there are not minimums.
Okay. Thank you very much.
And Mr. Chairman, let me just thank Jill and
Hang on, the author may have a question for
I
you.
just wanted to thank Jill and Jill Travis and CDL. We had an extensive conversation yesterday. We had another extensive conversation today, and I appreciate them taking an interest in this so that we can work on perfecting the legislation, and I did agree to work with them.
Okay. Thank you. I'm going to hang up on you, Jill, but since you're watching us online, we hope you'll continue participating. Thank you. All right. I see my friend Larry Johnson in the crowd. I'm going to respect your time and allow you to testify. You've signed up here, and we'll get you now. And then I have Walter Vinson from the City of Atlanta will be on deck.
Thank you, Mr. Chair. I would like to, if I can, because Ms. Sanford is a constituent, I want to, we have to respect our constituents. Can I let her defer my time to her?
You certainly can. All right.
Thank you.
Ms. Sanford?
Thank you so much, Commissioner. I used to live in a neighborhood for a long time. Commissioner Johnson is my commissioner as well, and I'm always contacting him about issues. But Thank you so very much for allowing me just a few minutes to be here with you today. My name is Bobby Kennedy Sanford, and as I said before, I'm a longtime resident, community activist in the DeKalb County area. I want to share briefly with you my recent experiences. A few months ago, on a lovely day, quite like the one for today, my daughter-in-law and my 16-year-old granddaughter had been to a mother-daughter meeting and had stopped by the local Walmart for a few purchases, and were headed home on a street, Columbia Drive, which is where both of our houses are very close to. And in the split of a second, there were gentlemen racing, or drag racing, or street racing down Columbia Drive. And in the split of a second, my daughter-in-law's life was taken, and our 16-year-old granddaughter was there to witness that. I felt such immense pain. I did not want to see ever another family have to experience that kind of grief. And I very rarely post on Facebook, but I did do a post saying that something must be done. I had no idea on a street where the speed limit is 40 miles per hour that there could be such a tragic and horrendous accident from someone speeding recklessly down the street. And I reached out, and I was inundated with support from many of the local civic and service organizations. We have a representative here with us today from Jack and Jill of America, and they are taking on this service project as one of their initiatives as well. But this is not a racial issue. This is an issue about life. This is a growing crisis. On the very evening of my daughter-in-law's funeral, there were people at the location where our office is located doing donuts. I think this is something that we must deal with. We must do something about this. Again, I'm so grateful for your allowing me this brief moment to speak to you. There are many who wanted to be here today, and I stand in solidarity with them, with the support that has been given to us for this project. I urge you, please, we must do something. No family is immune to this kind of violence. And I would not ever want to have another family. Look at my granddaughter waking up with no mom there. She's getting ready for cotillion. I had sons. I don't know what to do for a girl for cotillion. So she will never have her mother there when she graduates, each honor she has, when she marries. She will not have her mother there with her. And that is not fair to us. And again, no family is immune to this kind of violence. And I certainly encourage you and urge you. And if you don't mind, when I'm finished, I'm going to slip out because I'm going to get my second COVID vaccine in just a short while.
That's very fine.
But thank you for allowing me this time.
Thank you for sharing in your loss and grief, and hopeful that maybe some good will come from that through your efforts. And we appreciate you putting yourself out here today.
Thank you so
Thank you very
much.
much. Okay. Mr. Walter Vinson. You may speak either from the witness mic there or from this center chair on the table, whatever's most convenient for you. That'd be fantastic. I can activate that microphone just as easily as the podium.
Good afternoon. My name is Walter Vinson. I'm here to represent the city of Atlanta, and we're here to show support for SB 10, sponsored by Senator Jones. As you know, street racing is a problem here in the city of Atlanta and other surrounding municipalities across the state of Georgia. We are in support of this legislation to provide us additional tools to address the act. We've been in, like I said, we've been in conversations with the sponsor, Senator Jones, and we look forward to continuing conversation as the bill moves forward. But we just wanted to offer our support at this time.
Thank you. Does any committee member have questions? All right. Thank you so much
Thank you.
for sharing with us. I know it is a problem
Thank
in
you, sir.
Atlanta, and good to see you guys committed to trying to alleviate some of the problems we're facing with that.
Yes, sir. Thank you.
All righty.
Thank you for having us.
Okay, I think I'm reading this right. Justin Murray?
Yes, sir.
Okay.
Thank you all for having me today. I'm here to speak on Section 3 of SB 10 about the 650 horsepower rating and what constitutes a modified vehicle. When Senator Jones and I were originally talking about, we were gonna come up with a different horsepower rating, but then we started looking at different vehicle manufacturers and come to find out that most of the vehicle manufacturers have a horsepower rating less than 650. You're going to get, when you start getting to above 650, you're going to start getting to highly, exotic cars, Lamborghinis, Ferraris, specialty vehicles from Ford, like a GT 500, which is what we sell. So Corvettes don't even get to that range now. There's a couple.
You're
Dodge.
with Legacy Ford, just for the audience to know.
Yes,
is that
yeah,
right?
I'm a fixed operations director with
All right.
Legacy Ford. I've been there for 20 years. So, and so the reason why we chose 650 was because of the exotic cars. Most people who have a car over 650 horsepower, they're man, it's from the factory. They don't want to go to broadcast. That's why we chose that range for the tag. And in getting to the part of modifying a vehicle, the young lady on the phone said the only way she could tell that the car was modified was by having a dyno. That is untrue, unfortunately. You can look at the exhaust, you can pop the hood and see if the vehicle has an upgraded supercharger or has a supercharger, has nitrous, turbos. There's a lot of things you can look for. I mean, a simple training course could show an officer what to look for other than just having a vehicle on a dyno. A dyno is a very accurate way of getting a horsepower rating, but you can make probable calls just by popping the hood and looking under the car. So
It looks like the Dodge Chargers and Dodge Challengers are involved in a lot of this racing. What's their horsepower? Do you know?
depending on which one you get, there is a Dodge Demon that is 800 horsepower. It has two keys. One key is 500, one key is 800. It's just a simple changing of the computer. Most of the Chargers you're seeing today on the road that are like that are modified Chargers. They have come with aftermarket accessories, nitrous, superchargers, turbos, whatever, that can get them to what they need to have that power to weight ratio. So,
Okay.
and then whenever you get back to the modified section of the car, whenever you start changing the exhaust, you're going to get into EPA regulations. If you take the exhaust off, you're going to make more carbon monoxide, which is going to pollute the atmosphere even more. So, and that's why we kind of put that language, or talked about the language in there about the modified vehicles as well. So.
Any questions here for Mr. Murray?
Just to be clear, because I don't know much about cars, you're speaking in favor of the bill?
Yes, I am speaking in favor of the bill. We actually had a vehicle came in the other day at the dealership. Another dealership sold the customer a car. Come to find out, the car was used for drag racing. It was modified. It had a parachute tube, which is it's a tube on the back that installs a parachute to slow the car down from high speed. Car needed an engine. We since had the warranty voided on the entire car because it was not up to manufacturer specifications anymore. So, and Ford didn't want to pay for an engine.
Okay.
So,
Are you concerned at all that dealerships that sell these vehicles might be caught up in this as promoting or advertising drag racing?
wouldn't think so. Because most people who buy, like the people who buy the GT 500s from us, they know how much horsepower is. I'm pretty sure they would want to have a tag on the back of that car saying, hey, I have a high horsepower car. So most Mustangs that we see come into our dealership are base model GTs who have been bought down, stripped down to the bare minimum. So they could basically have, when I keep saying power to weight ratio is the less weight you have, the more power you have, the faster you're going to go. So that's why they buy stripped down models to do that. So.
Okay. Senator Jones, you're leaning into your mic. Do you got something you want to ask? Just paying rapt attention. Okay. Thank you, Mr. Murray. Appreciate you being with us.
Senator Jones, the vehicle ID number, far as one of the conversations we had is can an officer pull a vehicle ID number and tell them what that vehicle is equipped with from the factory? Yes, they can. Most manufacturers will have a VIN number, and it can be deciphered to tell you what engine's in it, what kind of exhaust system should have in it, what kind of tires and basic and stuff like that, and what factory engine it should have in it. So,
Okay.
so
All right.
all right.
Thank you very much.
Thank you.
Ms. April Moore with Jack and Jill of America.
Good afternoon. Thank you all for an opportunity to be here, and thank you to Senator Jones for allowing me to be here. Of course, you see I am in uniform, but I'm here representing Jack and Jill of America. Mom J was a member of our organization, and of course, this unfortunate incident occurred, and we are definitely in support of this bill, and we hate that we see things that are continuing to happen, and we also understand, especially with me being in law enforcement, that you have to strike a balance on both sides, and the hope is that we can come to a resolution that we don't end up with incidents like Mom J having to lose her life as a result of reckless acts by individuals that were not concerned about other people. So just on behalf of our Jack and Jill chapter, we want to say that we are fully in support of this bill, and hopefully the results will come out.
Did Jay Sanford work with Jack and Jill? Or?
So Jack and Jill of America is a mother membership-based organization, and you have to have children. So of course, all of the mothers that are in the organization have children, and she has a daughter, and her son had already graduated, but he had gone through the organization as well. And she actually chaired a committee, and I worked directly with her on that committee. So of course, it came as a shock to me, that I had just spoken to her, a couple of days before, and to get a phone call that she is, no longer here is difficult. And to know that this organization is specifically geared towards ensuring that our children are provided with opportunities to help them to be successful in the long run, and to know that now her daughter and even her son, even though he's older, will not have the opportunity to continue those experiences with their mother.
Well, thank you for being here to honor her
Yes, sir.
today. Appreciate your testimony.
Thank you so much.
Mr. Butch Ayers from the Georgia Association of Chiefs of Police. You'll be our last speaker on this bill.
Good afternoon. Thank you for allowing me to have the chance to speak on this bill. The Georgia Association of Chiefs of Police is in support of SB 10. We support Senator Jones in his attempt to bring forth some type of legislation that will create an effective deterrent to the laying drags and drag racing events that we're seeing not only in metropolitan Atlanta but throughout the state of Georgia. We hope to be able to work with Senator Jones to help perfect legislation that'll meet the criteria of the committee. Again, to create an effective deterrent to people who may even be considering participating in a drag race or laying drags. And again, we want to help accomplish the goal of basically addressing this dangerous behavior that is occurring behind the wheel of vehicles. Thank you.
I heard one of the speakers, and it may have been Senator Jones, say that this was a nationwide problem. In your position, are you hearing of this type of problem in other localities as well, or is it a Atlanta, Georgia, and surrounding area problem?
I would venture to say it's probably nationwide. I know for a fact that it's occurred in suburban Atlanta. I was talking to a chief just last week, and actually had an incident in their locality. Actually, some people came up to a major intersection in their city in the middle of the night, blocked the roadway so no traffic could come through. Then 2 or 3 of the vehicles sat there and did donuts for about 2 minutes in the middle of the intersection. And of course, by the time the police arrived, they had left the scene. So I don't think it's limited to inside the city of Atlanta. I think it's probably more common than we think.
Am I right that this is a fairly recent phenomenon, or its popularity has sort of sprung up in the last 6 to 12 months, or was I just living in a hole over in Athens and missing out on all the fun for for a while.
I would not doubt that that's true. I think a lot of the social media and the TV shows that you see out there that play up to enhancing vehicle specifications and getting out on the roadway and doing things. We had a case when I was, prior to my retirement, actually on Interstate 85, where we had people block off the intersection, and they would get up and go northbound in the southbound lanes from one exit to the next in an exhibition of speed, drag racing in the middle of the night, hoping nobody would come the other way. So, and again, that was 15, 20 years ago. But I think that, some type of legislation that creates that effective deterrent to know that there are meaningful penalties if you do participate in this highly, highly dangerous behavior.
And do you know what the current penalty is for drag racing?
I know you were going to ask me that, and I would probably have to refer back to, I guess, if Mr. Scandalakis is here, might be able to answer that question, but I don't know the offhand answer.
That's fine. We'll follow up. Thank you very much for being here. Any questions for Chief Ayers from committee? Okay. Thanks for being here with us. Senator Jones, given the fact that the committee sub wasn't really ready till today, and I think most people need a little time to digest this and look at perfection, I think, as you called it, we will not be holding a vote today. Chairman Strickland of Judiciary Committee will either go ahead and refer the bill back from subcommittee to the main committee for further action, or else will allow us to take action here and then sort of streamline that process, kind of depending on scheduling, availability of rooms, and committee time here. But thank you for your efforts, and a very thank for everybody for presenting today. That was very beneficial to this committee in the process. And now I call you, Senator Harold Jones, with SB 18. If you would, you might be more comfortable out there at the witness seat for camera purposes. And you're welcome. Thank you, Senator Jones. This bill is also in your folders for committee members. It's we're working off of LC 412698, Senate Bill 18. Floor is yours, Senator Jones.
Okay, thank you. Working off LC 412698. This is an opportunity for Georgia to join various other states by eliminating statute of limitations for 3 offenses, which is rape, aggravated sodomy, and also aggravated sexual battery. The other states which has also done this are California, Illinois, Kentucky, Maryland, North Carolina, South Carolina, West Virginia, Wyoming, New York, and also Virginia. And so this would eliminate the statute of limitations for 3 offenses, which is rape, aggravated sodomy, and also aggravated sexual battery. Please note that all 3 of those offenses actually involve force and against, of course, a person's will. So rape, of course, is forcibly and against will. Aggravated sodomy involves force. Aggravated sexual battery involves a foreign object, and also, of course, without consent. In addressing this, if you look at literature and also just in speaking with persons, you have some primary concerns that have come up, and I'd like the opportunity to address those. And one of the main concerns that comes up is the time period which may have elapsed, that at that point in time you may have just one person's word versus another. I would say that, number one, our legislators already kind of answered that question in this sense. Under OCGA 1732.1, if a person is under 16, a prosecution can be commenced at any time for similar offenses for rape or aggravated sodomy. So in that sense, the issue about whether a person's memory is still good, whether the issue would just be one person's word against another, we've kind of already addressed that in that particular statute. So if a person is under 16, they're able to bring that charge. Prosecution can be commenced at any time. Prosecution can also be commenced at any time under DNA is used to establish the identity of the accused. And those offenses are armed robbery, kidnapping, but key ones for our purposes is rape, aggravated child molestation, and also aggravated sodomy. So to address the issue about a person's memory may be bad or that it may only be he say versus she say, our legislature has addressed those and said that we trust the process, that we trust the system. Because if a person is under 16, we allow them to go forward. Prosecution commits at any time. We trust the process and system if DNA is used to identify the accused. But please note that DNA, when we talk about that, that does not solve the crime. That it only identifies that this person is involved in that. It does not eliminate the issue of consent at all. So one of the big issues when you start talking about rape or aggravated sodomy or aggravated battery, sexual battery, is always going to be not only the force, which could also be used regardless of DNA, but also the consent. That issue still exists. And so I think our placement and say, well, we allow it for DNA because it gives us some type of scientific basis, it really doesn't. It just adds one piece to a very intricate puzzle as far as proving that particular case. But it doesn't prove all the elements of your case at all. So we have eliminated the fact that you need a statute of limitations for under 16 and also for DNA. This legislature has already said that they trust the process. And so I would also, in addressing the memory aspect of it, point to different psychologists, one by the name of Jim Hopper, professor of psychology at Harvard Medical School and research in neurobiology, who states that severe trauma is actually imprinted upon our brains and our memories, which they basically do not fade. That you may not remember small details, but the traumatic experience itself is imprinted, and in fact, the possibility of those memories not fading does not exist. I would say that this legislature actually adopted that principle and that function or that philosophy when we said that a person under 16 can bring these charges at any time. I guarantee you that part of that rationale was that this is a very traumatic experience for a child, and so therefore it's imprinted upon them, and so therefore when they come forward, we can sort of believe it. Not only that, I guarantee you we also said that the process still had to play itself out. That process being the police, that process being a prosecution, that process being a grand jury, a defense attorney, a judge, and then a jury, and other surrounding circumstances that can affect a trial. We trusted that process. We said that we believed that that imprint on that child's brain was so great that they could bring the case at any time. But for some reason, though, we've gotten stuck, and I use the term we because I'm part of this process in the sense that we all have to kind of wrestle with this, and I've had to wrestle with this too because I've grown up in the same system we all have grown up in. And that is, for some reason, all of a sudden the imprint on the brain isn't as strong, and I think the deeper problem that we have maybe is because now we're dealing with an adult woman. And that we're okay saying that the imprint on the brain is fine with a child because we believe we're protecting children. But some kind of way that same logic and actual fact loses itself when we say we're going to protect adult women. So under 16, the impact on your brain is strong enough, and we trust the process. But the day you turn 16 or 18 or 20, and now you're an adult woman, the traumatic experience on your brain that we trusted before is now gone. The process that we trusted before is now gone. And I would say that's part of what we all must wrestle with as far as our aspect and how we look at our relationship with believing adult women. On the issue of DNA, I'll also make somewhat the same argument. As I stated, with DNA does not prove the case. It does not. Because a person can still say, that was consensual. That was absolutely consensual. And guess what? You're still stuck with what I've heard periodically, he say, she say. You still have that. But what this legislature said by moving forward and saying we'll allow DNA is that we trust the process. Yes, that man, and let's also understand with some of the other offenses, it could be man on man, it can be also intergender offenses too. But that man can say, that was totally consensual. Yeah, you have my DNA, I got it. But that was absolutely consensual. You're stuck with the same thing that I've kind of heard about, was he say, she say. That hasn't proven anything. That did not prove it. But why are we allowing that to go forward? Is because we trusted it. But I also would say something else about that I think that we have to wrestle with. To some extent, when we think about DNA, we think about it catching the serial rapist, that now the person has been convicted and they're in jail and they're serial rapists and there's a big guy in jail. And I would say that what we're really trusting is the fact that we have this guy more than we're trusting the adult woman story. Because, and that's only logical, because all the issues that you're giving about memory, he say, she say, it still exists within a DNA case. So what we're really trusting is what we see on television. We have a serial rapist who gets picked up and, well, he's automatically guilty. We're not really still believing the person who's bringing the charges. We're not really respecting her humanity. What we're really respecting is, well, we got this big guy over here in jail with a bunch of tattoos. He did it, because that's what we see on TV. But that doesn't necessarily have to be the case. The DNA hit could just be a quote-unquote regular guy who would sit there and tell you, I absolutely had sex with her, and it was consensual. You still are stuck with those same issues. And I'm sure this legislature was given those examples. And this legislature said, we trust the process. We trust our defense attorneys. We trust our prosecutors. We trust our police. But for some reason, when we say, okay, we don't have the DNA, we don't have it as a child, what we have is an adult woman who's trying to recapture her humanity, all of a sudden that process can't be trusted. And I think we're better than that. And I think that logically, if we look at the laws that we've already passed, this is just a natural step as far as we're going into these particular laws. The last thing that comes up is, why wouldn't a person come forward? And last year when I did this, I actually used various examples about the fact that maybe it involved her boss, maybe it involved a close friend, maybe it involved drugs or alcohol. And quite frankly, if that helps move this forward, not only today, but to get passed and signed, if those are examples that will help people, I encourage you to use them. I would not necessarily use those examples for my purposes. Because as I wrestled through this, I thought to myself, as you see with aggravated sodomy, aggravated sexual battery, where if this happened to me? Can, because these charges apply to a man. I would not have to prove my humanity to anybody. People would automatically assume that it was gone. People would automatically say, God, this is terrible that this happened for you. People would say, you need to take charges. People would probably believe. But also, how would I feel as a person when I looked at myself in the mirror, when I thought about the fact how my humanity was taken from me? How difficult would it be for me to even go get that back? And I would be believed. Nobody would even question about my humanity was taken. Those are just the facts. And so that's where I came to the conclusion, stop using all those examples, because you would not have to use those examples. And if those examples help persons get to a certain point, I encourage you to use them. But I would not have to say it was my boss. I would not have to say it was a friend. I would not have to say I was drunk. I would have to just say this is what happened. Now, the process would still have to work, there's no doubt. But I would have to say this is what happened, and no one would question that my humanity was taken. No question about it. And so, therefore, when I do this, I say I can't use those examples, because what is going on, the main reason she may not have come forward is because she had to get the courage to take her humanity back. But it was lost, no doubt, from mine. And it doesn't matter what that reason is. I don't care if it was a friend or a boss or drugs or alcohol was used. Doesn't matter. The humanity was taken, and that should be what we are trying to protect. In conclusion, as I stated, we have answered the memory question, the he say, she say question. Logically, this is just a next step. And I also will point out that over the course of the next 30 days, there will probably be a couple of times where we'll give a standing ovation to police officers. We'll give a standing ovation for prosecutors. We would trust them. But for some reason, when it comes to an adult woman who brings these particular charges, and I do acknowledge this can happen to other persons too, but for some reason when it comes to her, all of a sudden now we don't trust the prosecution, we don't trust the police, and we think they're just going to run out and go put people in jail. Something that they don't do now, in the sense that that's an issue that a lot of women face today when the case is more fresh. So now, when the case is not as good, and understand when we have a period of time, the case doesn't get better. So now when the case is not as good, all of a sudden the prosecution and the police, they're just going to run out and arrest persons where many women would say that reality doesn't even exist today. So when we give those standing ovations, we can't pick and choose when we give them. If we trust them, and we've already proven we trust them with the under 16 and with the DNA, we've already proven that we trust that process, then we have to let go of these biases that we have and trust the process now for an adult woman, wasn't a child, doesn't necessarily have DNA, and she's coming forward. And we'll allow that system that we're going to congratulate, that we're going to give a standing ovation to over the course of the next 30 days, allow that system to work the same way it has to work with the other exceptions that we've given. So I think we should join these other states and move forward on this particular legislation, and at that time, make sure that we change the dialogue as far as this particular crime is concerned. Thank you, Ms. Chair. I'll be open for questions.
Recognize Senator Kirkpatrick for a question.
Yeah, I got a couple things. I'm very interested in this bill because I serve on the Commission on Family Violence, and I had two questions. One is, just to be clear, there's no look back, right? This starts...
That's correct. It is not retroactive.
Going forward only.
That's going forward only.
Okay, and then the other question is, there's a lot of attention being paid to human trafficking by the governor and many others, and I just wonder how this plays into that. This seems like it could be very relevant to a human trafficking situation as well.
I would think that it would. I would think certainly the possibility that does exist, and would be glad to look into that. You know, other persons have kind of taken on that human trafficking kind of element, but as a former prosecutor, I'm very interested in, especially in domestic violence. That was one of the areas that I was very concerned about as a solicitor. So absolutely.
Go ahead. Do you have a follow-up question? Okay. I was here in 2012 when we had those amendments, and my recollection is a little bit different, that it was not focused so much on the impressions or the memory of a young victim, but the vulnerability that we felt like we were protecting younger children from sexual abuse. And that, if I recall correctly, and Pete Skandalakis might know better than I do, I think we also protected people over the age of 65. You know, the same type of extension of the statute of limitations. Not to doubt your, it might also be equally valid reasons why some senators voted for those provisions back in that time. But thank you for the effort and energy you've put into this, not just this year, but in the past as you're perfecting your legislation. We do have several people signed up to talk, and before they run us out of the room, I want to let them have a talk. Pete Skandalakis, Prosecuting Attorneys Council. I'll introduce you. If you'll come on forward, I'll light you up there on the mic. Have at it.
Thank you, Mr. Chairman. There's not a lot I can add to what Senator Jones has already said, and he was very impassioned about it and very articulate. But since 2002, the legislature has tried to address the inequities that are involved with the statute of limitations and has done a pretty good job, but there's still some gaps in there that need to be addressed. Mr. Chairman, you're absolutely correct. In 2012, the statute of limitations was eliminated, and this answers Senator Kirkpatrick's questions for people under 16 for the following offenses: trafficking a person for sexual servitude, cruelty to children in the first degree, rape, aggravated sodomy, child molestation or aggravated child molestation, enticing a child for indecent purposes, and incest. And that's all for crimes committed after July 1st, 2012. As a prosecutor, I can tell you one of the most difficult things that we've had to deal with has been this hodgepodge of statute of limitations that wasn't created by our legislature in the 2000s, but prior to that, and our legislature's been trying to address it since the year 2000. For example, 2002, and I can't remember the specifics, but there's a statute of limitations now that says any offense that occurred after 2002, we can prosecute those cases, and particularly involves children. Well, if you had a child that was molested prior to that, we're basically out of luck, because those offenses have to have occurred after 2002. And I think what Senator Jones is talking about, the same thing, is that we have to bring some clarity to the issue and some justice to the issue. And he's absolutely right. Anytime I've prosecuted more cold cases than I care to even remember. And I can tell you, regardless of what type of cold case it is, you're evaluating the case not only based on what the victim said, and sometimes a cold case might be a homicide, so you don't have what the victim said, but you're prosecuting that case and you're evaluating that case based on the evidence available to you. Do you have DNA? If you do have DNA, can you corroborate how the DNA got there? Do you have credible witnesses? Did your witnesses come forward in a timely manner? Did they not come forward in a timely manner? So all that goes into evaluating a case and whether or not you even have a case. Senator Jones has pointed out correctly that there are a number of states that have no statute of limitations. I happen to have the pleasure and the honor of speaking to a group of prosecutors in West Virginia. They've never had a statute of limitations on any felony. That is everything from theft by taking to homicides. Never a statute of limitations. And again, they evaluate the case the same way we do. Can you get a conviction beyond a reasonable doubt? Do you have sufficient evidence to overcome a skilled defense attorney, as we all know, the many skilled defense attorneys? Do you have sufficient evidence, corroboration, credibility, and physical evidence that'll help you overcome those boundaries? So the prosecutors in this state support Senate Bill 18, and we hope we will continue to work with Senator Jones. If this committee has questions, we'll go back and do our research and answer the questions, but we sincerely appreciate the support you give Senator Jones on this bill, Senate Bill 18. And I know your time's limited, so I'll stop talking.
But let me just, to educate any listeners, why do we have statutes of limitations? You said West Virginia doesn't have them. Georgia has them, and they vary in length, essentially depending on the severity of the crime. For example, murder, there is no statute of limitations. And if there is DNA evidence to prove the identity of the accused, there's no statute of limitations on these type of cases we're discussing today.
Prior to the development of DNA evidence, we still had statute of limitations. As we've learned that DNA can help us solve crimes that occurred many years ago, we've adapted, and we've gone forward. I guess the policy would be there has to be some finality towards a crime. I'm not really certain why we have it, and I would have to do some research as how that came about.
Well, I was taught in law school that it's partly a due process issue for the accused to allow them to adequately provide a defense for themselves to refute false allegations. And you need witnesses to do that. And if they're dead, if something happened years ago or you don't remember them or can't find them, they've moved or whatever, it makes it more and more difficult to refute.
I think that's yes, sir. I think that's part of the reason, but that also applies to a United States Constitution right to a speedy trial, and that you still have to, even when you told, for example, the accused is unknown at the time of the crime committed, and then the crime's committed. Now you know the accused, so now you can begin the prosecution of the case. This
doesn't require that, though. A prosecutor could wait until somebody's on their deathbed, but once they bring the charges, then the accused can demand a speedy trial. But you can't say, I've been accused, I'm a suspect, and demand that you be indicted.
No, if the suspect is known to the prosecution and the prosecution causes undue delay in the case, your United States constitutional right to a speedy trial starts running when that person is known to the prosecution. So if that person is known to the prosecution and for some reason the prosecution just decides not to prosecute the case because, let's say, this defendant has witnesses and is waiting for those witnesses to become unavailable, a defendant has a constitutional right to a speedy trial that begins when that suspect is known.
Okay. And I'm playing a little devil's advocate because you're in that role as the prosecutor, but I helped sponsor, I might have been the sponsor on a bill a few years ago on these lineups and police procedures and prosecutorial procedures for eyewitness identification, because we had learned that was unbelievably one of the least reliable types of evidence. which is, I think, one reason we have an exception for DNA, because it corroborates the identity of the person that's been accused. And it was amazing, some of the people that have been exonerated by DNA evidence that were, identified in lineups. In fact, I remember one case that the actual perpetrator was in the same lineup.
That was my case, by the way.
That's what I was thinking. I'm throwing you a softball.
Now that when I say that was my case, it was prosecuted not by me but by my predecessors, and yes, that case occurred and DNA cleared that person. And I would say that yes, lineups have been proven to be problematic at times, and police officers and law enforcement agencies have done a lot to improve the method that they use lineups. But I'll also tell you that as a prosecutor, if all you have is a 20-year memory and you have a lineup, you better have more when you evaluate that case, even if you don't have DNA. Let's just say you don't have DNA. Going on eyewitness identification only, and that's all you've got, would make it very difficult to proceed on that case. And I've had a lot of rape cases where, as Senator Jones has said, it's a he said, she said. I mean, he said he didn't use force, she said she used force. And we have to look a victim in the eye and say, listen, I'm sorry, we do not have enough to go forward. It's not that we don't believe you, it's that we can't prove that case beyond a reasonable doubt. And I think the same thing would prove on an eyewitness identification, like you said. I've had many cases where the only witness we had was eyewitness, and we want more. We want more because, again, a good defense attorney can pretty much chew up an eyewitness identification.
All right. Thank you so much for being here with us.
Thank you,
today.
Mr. Chairman. I appreciate you.
I don't know if I'm reading this correct. Is it Pat Kelly or Patricia? What's your name?
Yes, Mr. Chairman. My name is Patty Kelly.
Patty. Okay, I didn't see
and
the dot on your eye there. All right.
Yes. My name is Patty Kelly. I'm a lifelong resident of the state of Georgia, and I am a volunteer speaker for RAIN. Rape is the worst.
What does RAIN stand? It's RAINN. That's your organization?
It's not really my organization. I'm volunteering. It is the Rape and Incest National Network. They have a toll-free number that victims can call and talk to a live person when they need support. It's a great organization, and I am speaking. They contacted me because I have volunteered for them, and I have a case that fits this bill. Rape is the worst crime that can happen where you have a person who survives. So much is taken away. The personal losses are incalculable. But in spite of how horrendous rape is the most underreported crime. Some people don't report because they don't think it'll do any good. They won't be believed. They will be judged, further humiliated, and just make the pain worse. Some of them have fear of the perpetrator. They're in shock, and there is pain in retelling the trauma. After all of these years, coming here and sharing with you today still opens old wounds for me. But when I was a 19-year-old college student in Athens, I was kidnapped at gunpoint from a convenience store, the Golden Pantry across the street from the Athens Mall. I was driven with a knife on my neck to another county. I was physically abused, raped, and threatened with death by a stranger who was over twice my age. The assailant was an angry, vindictive rapist whose goal was to humiliate and degrade women through rape, abuse, and sexual violence. And because he was armed and dangerous and unpredictable, I had to make choice after choice after choice to do what he demanded in order to live. In the end, he contemplated my death, but said he did not have the heart to kill me. I was taken to the hospital for a rape kit and for a physical exam, and I went to the sheriff's office for a composite drawing. To say I was in shock is an understatement. I was a shell of the person I was before. I felt like something most sacred and precious had been viciously wrenched from me. I couldn't remember how I used to sit or stand or even hold my own arms. My world was turned upside down, and it was no longer a safe place. I was damaged for life, so I believed, and I just thought, how does someone get over something like this? my life would never be the same. My family tried to help me and said, just gloss over it and don't worry, we won't tell anyone. That just sent the message home that this is not something you talk about, and they did not even know the worst of it. I cooperated with the police from the moment I was found. They were already doing a grid search around the store looking for a body because there were signs of foul play. I went back with the police to the crime scenes. I went to look at weapons, which was very difficult in my condition. I was tested for STDs. I was interviewed and re-interviewed. The night I did the composite drawing, I did not know it, but the detectives recognized the suspect. He had been released from prison in the previous 12 months for attempted rape. I picked him out of a lineup, and he failed a lie detector test. He also had physical attributes. His voice, I asked, could he please speak? I spent an hour and a half with this man, and I picked him out of the lineup. But I did not know that the detectives recognized him from the drawing. I did not know they had a suspect. I didn't know he had been in prison. I did not know he failed a lie detector test, and I did not know that I'd even picked him out of the lineup. I was never given that information, and I was never given the option to go to court. At some point, I just stopped hearing back from the detectives, and he was never charged or prosecuted. The memories of what happened that night are etched in my mind forever. I cannot forget them no matter how hard I try. I believe that's why so many victims turn to drugs or alcohol, just trying to forget, but it does not work. Eventually, I went to counseling, and I had to work hard through the details of that night, which is why I'm able to testify today. In closing, the rape was reported immediately, and I cooperated fully. Yet justice eluded me because I was not given the opportunity at the time to face my assailant. And when I came back years later, the statute of limitations failed me. I contacted law enforcement years later and asked if there was any DNA they could test, only to be told by the Athens District Attorney's Office that the statute of limitations had expired. Emotional healing from such a traumatic experience takes much longer than physical healing. It does not seem just to place an arbitrary time limit on healing from the worst trauma imaginable. And as I look back as the grown woman I am today, I can still feel and remember that devastated, young, shot, broken young woman I was then who didn't know how to go on living. I thought it would be better to die with some dignity and self-respect than live with the painful memories of that night. But I believed I survived for a time such as this, to be a voice for those who do not have their voice yet. This is where justice starts, in these walls where you hear the cries of victims. Justice cannot work out there until the law is changed in here. I will not see justice. I will not have my day in court. But if this bill is passed, it will feel like justice. I will feel like a wrong was made right. It will allow Georgia to use for good what man meant for evil. Passing this bill will help keep Georgia safe. It will help keep rapists from doing it over and over and over. It will help support victims. It will help give them time to heal. It will help give them a voice. And it will help to open the doors of justice. Thank y'all so much for giving me a voice today and allowing me to speak to something very dear to my heart.
Ms. Kelly, I want to thank you. I remember your story from living in Athens, and I never had a, face to the name. And you're an incredibly strong and brave woman to share your story with us today, as painful as that must be to you.
Thank you,
you
sir.
for participating in our process.
Yes, sir. Thank you.
The organization that Ms. Kelly volunteers for, RAIN, has the National Policy Manager, Sean Holohan, has been in communication with me to make suggestions concerning this bill and to advocate for this bill. And he has recommended that in addition to the language provided in the bill, think it would be good to add the following to a statute of limitations bill. Testimony from other victims which provide similar motive, intent, and opportunity to have committed the crime. Corroborative testimony at the time of the crime which supports the allegations. Digital evidence including images, videos, emails, texts, chats. Sometimes these perpetrators brag or repeat it. Medical evidence consistent with the sexual assault, and testimony from professionals and others with direct and contemporaneous knowledge of the alleged criminal acts, including mandated reports. And of course, all of that's in addition to DNA he and I had discussed. Was there DNA gathered in your case?
No, sir. Well, they took everything I had on, every stitch of clothing, and they kept it. And that is why I asked about the DNA testing. But it's my understanding in less than half of the cases of rape, in over half the cases, there is no DNA present. Yeah. And this was not a crime about sex. This was a crime about power and humiliation. And so there was no DNA that I'm aware of.
A final witness again, Butch Ayers is back. Georgia Association of Chiefs of Police. Love to have your perspectives here. So we're kind of, the clock is running out on us, but you take as long as you need.
All right, I'll try to be quick. In 2019, legislation was passed by the state of Georgia that required local law enforcement agencies to hold evidence for up to 30 years. And of course, with the passage of this bill, that will be required to hold additional evidence forever. The Georgia Association of Chiefs of Police supports the bill in its entirety. I think it's something that needs to be done. We need to hold the offenders accountable. We need to hopefully help bring some type of closure, if at all possible, to the victims. But one of the things I want to talk about is evidence. To have a case and to be able to present it for prosecution, you have to have evidence. We have to maintain the evidence. And probably one of the quickest ways to lose a case in court is for the evidence, the accuracy, and the chain of custody of that evidence to be questioned. And right now in the state of Georgia, we have over 600 different law enforcement agencies in this state, and they all probably have evidence rooms and are probably all doing it a little bit different from everybody else. Some agencies have the resources to have a well-run, well-equipped, and constructed evidence room, and other agencies do not. We believe that the evidence in cases like this, should be stored in one consistent manner in a climate-controlled facility for all agencies in the state. Currently, the state of North Carolina requires that this type of evidence be held indefinitely, and therefore North Carolina constructed a facility to hold and maintain that evidence. We believe the state of Georgia should consider doing the same thing. We propose that consideration for the formation of a study committee to examine the feasibility of constructing and operating a centralized storage facility to be operated by the GBI for certain crimes that require long-term storage of evidence. And again, I wholeheartedly support the bill, and we look forward to working with Senator and this committee and seeing it through fruition. Thank you.
Any questions? Okay. Thank you very much for being with us. All right, we will report back to Chairman Strickland and see whether he's ready to just go ahead and move the bill to the big committee or wants to discuss with you, Senator Jones, any perfection or changes to it before we voted. Thank you so much for all the energy and time you've spent on this issue. And today's hearing really is powerful to show that this is as much about the victims as the perpetrator, to get closure, to have peace, and to hold people accountable for what they've done to you. And I think that's a point that's not missed by this committee. And thank you for advocating for these victims, Senator. Appreciate you. All right. We are adjourned.